Mooting is an extracurricular activity where two teams of two students studying law compete in a simulated appellate-level court proceeding. At UNSW, mooters prepare written submissions and present their arguments through oral submissions. This video will provide a demonstration on how a moot works. 6 days before your moot, you'll receive a problem question email, which contains the problem question, hints, written submission template, mooting handbook, and competition rules. Moots are conducted between two teams of two, but are judged individually. The side that is initiating the case is the appellant, and the side refuting the case is the respondent. The problem question email will say who is on which side. The problem question is designed to be easily divided between two people. Contact your partner and decide whether you will be speaking first or second. If you are speaking first, you will be the senior counsel. If you are speaking second, you will be the junior counsel. Both roles will be judged equally. Before the moot, you'll be required to prepare written submissions. These will be due 2 days before the moot. Mr. Lance Woods, the appellant, recreationally cycles at Millennial Park every morning before cycling to university to attend class. He is an experienced and confident cyclist who always wears a helmet and reflective jacket. He knows that cycling on Sydney roads can be dangerous because his friend died while cycling on a freeway 2 years ago. On Wednesday, 3rd of March, Mr. Woods got carried away with cycling at Millennial Park and was running late for class. To get to university, he had to cycle to the other side of the park. While cycling, Mr. Woods cycled past Miss Sarah Mulville, the respondent who was driving a vehicle. She had just finished eating an apple and threw the apple core out of the driver's window. The apple struck the front wheel of the bike and caused Mr. Woods to be thrown off and injured, ultimately suffering a fracture to 2 vertebrae. Mr. Woods brought an action in negligence against Miss Mulville, which was unsuccessful in the New South Wales District Court, and he is now appealing to the New South Wales Court of Appeal. In the matter of Woods and Mulville, the New South Wales Court of Appeal is now in session. The court will now take appearances.
May it please the court. Your Honour, my name is Anthony Ma, and I appear with my learned junior, Andrew Tutos, representing the appellant, Mr. Lance Woods, in this matter. May it please the court.
May it please the court. Your Honour, my name is Alice Williams, and I appear with my learned junior, Elliot Anthonys, representing the respondent, Miss Sarah Mulville, in this matter. May it please the court.
At the beginning of the moot, the judge will call the matter by reading out the case name and requesting appearances. During appearances, the senior counsels on both sides will introduce themselves, their partner, and who they represent. Thank you, counsel. We will now hear from the senior counsel for the appellant.
May it please the court. Your Honour, this case concerns the injury suffered by the appellant, who was thrown off of his bike after it was struck by an apple core thrown by the respondent. The appellant was cycling to university on a road shared with vehicles on his way to attend class. He was wearing a helmet and a reflective jacket. The appellant now seeks to overturn the finding of the trial judge that the respondent was not negligent. Here I have provided a brief summary of the facts of the case. The purpose of the summary is to give context to the case and draw the judge's attention to key details. It's approximately 30 seconds long and highlights pertinent facts without being overly biased towards the appellant. It also doesn't address legal issues, as these will be addressed later. As a bit of an aside, if you make your factual summary biased rather than objective, you will likely draw early questions from judges, which will eat into your time to make legal arguments. Keep the facts concise and objective. Your Honours, the question before this court today is whether the respondent is liable for the injuries of the appellant. We will therefore be making two submissions. First, that the respondent is liable because the appellant was not engaged in a dangerous recreational activity. And second, that the respondent is liable because the injury was not caused by an obvious risk. I will be addressing the first submission, while my learner junior will address the second submission. Before I get to the substantive legal arguments, I clearly outline the structure of my arguments. This is done through signposting, which means that the arguments are numerically listed and referenced throughout the submissions. The purpose of signposting is to assist the judges in keeping track of your submissions. Your Honours, I will now turn to the first submission on dangerous recreational activities. Section 5L of the Civil Liability Act 2002, New South Wales, states that there is no liability for the materialisation of an obvious risk of a dangerous recreational activity. Section 5K defines a recreational activity as any sport, any pursuit or activity engaged in for enjoyment, relaxation, or leisure, and any pursuit or activity engaged in a place where people ordinarily engage in sports or pursuits or activities engaged in for enjoyment, relaxation, or leisure. This section also defines a dangerous recreational activity as a recreational activity that involves a serious risk of harm. Thus, there are two lines of inquiry. First, whether the appellant's cycling is a recreational activity, and second, whether the appellant's cycling is dangerous. For the appellant to succeed, it must be proven that either one of these inquiries is false. Arguments should be structured according to IRAC, which stands for Issue, Rule, Application, and Conclusion. The issue is the point of contention between the parties. Here, I have started my argument by identifying the issue as dangerous recreational activities. Rule refers to definitions and legal tests that need to be applied to resolve the issue. When addressing rules, always cite legislation or case law. Here, I've used the Civil Liability Act 2002 New South Wales to establish the rules by defining what a dangerous recreational activity is. I have also established what must be proven in order to be successful. Where a legal test or concept has multiple steps, it is helpful to signpost. Here, I've signposted by dividing the dangerous recreational activity test into two parts, whether the activity is recreational and whether it is dangerous. I will now address whether the appellant's cycling was a recreational activity. Turning your honours to paragraphs 5 and 6 of the facts. The appellant was cycling to get to university. It is our submission that this does not meet the definition of a recreational activity for two reasons. First, the appellant is not cycling for the purpose of relaxation, leisure, or enjoyment, but instead is doing it as a method of travel. Secondly, at the time of the incident, the appellant was not in the park, as he was not in a place where people ordinarily engage in sport or activities for recreation, relaxation, leisure, or enjoyment. The appellant is therefore not engaged in a recreational activity. Here, I have applied the facts of the case to the rules previously established. When referencing facts, make sure to cite the paragraph number and pause briefly to allow the judges to find the paragraph. Also note that I signpost my argument by dividing my application of the facts into two parts. I then draw a final conclusion at the end to conclude my first submission.
Counsel, Section 5K of the Civil Liability Act also says that any sport can be considered a recreational activity. Since cycling is a sport, is it not a recreational activity no matter the reason for cycling?
No, Your Honour. Although we concede that cycling might be considered a sport, it is our submission that there is a clear distinction between cycling as a sport and cycling as a mode of transportation. For example, walking is a common mode of transportation. However, some people also walk as a sport for fitness. Therefore, a distinction must be drawn between an activity done for sport and the same activity done for transportation. Judges will frequently interrupt submissions to ask questions. Questions should be answered as directly as possible. When answering, say, "No, Your Honour," or "Yes, Your Honour." Then succinctly answer the question before turning back to your submissions. I now turn to the second part of the dangerous recreational activity test, which is whether the activity is dangerous. Section 5K of the Civil Liability Act states that an activity is dangerous if there is a significant risk of physical harm. A significant risk is defined by Justice Ip in the case of Phallus and Morlus, reported in 2006 in volume 65 of the New South Wales Law Report, starting at page 418. Your Honour, may I dispense with formal citation?
Yes, Counsel, you may.
Thank you, Your Honour. Justice Ip defined a significant risk as one falling between a trivial risk and one likely to materialise. This is an objective test, considering, among other factors, the likelihood of harm, the time, place, competence, and equipment. If you are senior counsel, ask your judges if you may dispense with formal citation after fully citing your first case. You do this once and then no longer need to provide the full citation of any further cases you reference. There are two types of cases that you can cite: leading and analogous cases. Leading cases are cases that establish a rule or legal test. These are typically cited in the rules section of IRAC. Here, I've used a leading case to establish the test for a significant risk of physical harm. Analogous cases are cases with similar facts to the case being argued. These are typically cited in the application section of IRAC and in response to questions from judges. Analogous cases can be used to draw similarities to the current case if they have a favourable outcome. They can also be used to draw distinctions with the current case if they have an unfavourable outcome. Your Honours, paragraph 1 of the facts states that the appellant is an experienced cyclist, while paragraph 5 of the facts states that at the time of the incident, he was wearing protective equipment, as competence and equipment are relevant considerations for dangerousness. These facts must therefore weigh towards a less than significant risk of harm, thus making cycling not a dangerous activity.
Counsel, even with protective equipment and experience, the appellant was still cycling alongside cars. Is that not dangerous? Furthermore, your learned friends cite in their written submissions the case of Renman, which ruled that bike riding was a dangerous recreational activity. What do you have to say about that?
Here I have made good use of a pause. If you are asked a tough question, you can pause for up to 10 seconds to collect your thoughts and structure an answer. Your Honour, to answer your first question, no, it is still not dangerous. The case of Valvo states that a significant risk of harm materialises with a low likelihood and catastrophic harm, or a likelihood and harm that is more than trivial, as the experience of the appellant makes the likelihood of harm low, and the equipment of the appellant reduces the magnitude of harm. Cycling is therefore not dangerous. Turning then to your second question, we distinguish the case of Vermin on 2 points. First, Vermin addressed BMX bikes, not ordinary bikes like what the appellant rode. BMX bikes are faster and thus more dangerous than ordinary bikes. Secondly, in Vermin, the bikes were used for bike jumping, which is inherently more dangerous than cycling on an ordinary road to get to university. Thus, the case of Vermin can be distinguished from this case. Sometimes judges will ask 2 questions at once. When this happens, ensure that you answer the questions one at a time. Here, I have clearly signposted which question I am answering. Also note that to answer the first question, I've applied facts to the rule from a leading case to draw a favourable conclusion. To answer the second question, I have drawn factual distinctions between the current case and an unfavourable analogous case. These are both persuasive ways to answer questions using cases. Your Honours, the appellant was therefore not engaged in a dangerous recreational activity, as cycling for the purpose of transportation is neither recreational, nor does it pose a significant risk of harm. I will now kindly pass on to my learned junior, who will address submission 2 on the materialization of an obvious risk. May it please the court, those are my submissions.
Thank you, Counsel.
If you are senior counsel, you conclude oral submissions by drawing one overall conclusion regarding your submissions, followed by passing on to your junior counsel. End by saying, may it please the court, those are my submissions.
I will now hear from the junior counsel for the appellant.
May it please the court. Your Honours, I will be addressing submission 2 on the materialisation of an obvious risk. Section 5L of the Civil Liability Act states that there is no liability for the materialisation of an obvious risk of a dangerous recreational activity. Section 5F of the Civil Liability Act defines an obvious risk as one that is obvious to a reasonable person in the position of the appellant. Always begin your oral submissions with, may it please the court. As junior counsel, you can get straight into your substantive legal arguments as senior counsel has already summarised the facts and outlined the structure of your submissions. Therefore, Your Honour, as an apple core being thrown out of a window is neither a matter of common knowledge, nor is it a risk reasonably associated with cycling on a road. It is not an obvious risk. Overall, as cycling to university is not a dangerous recreational activity, and an apple core being thrown out of a window is not an obvious risk, the appellant was therefore not injured by the manifestation of an obvious risk of a dangerous recreational activity. Thus, the respondent is liable for the injuries of the appellant. We ask that the appeal be allowed, the orders made by the trial judge be set aside, and in their place, a finding in favour of the appellant with costs be substituted. May it please the court, those are our submissions.
Thank you, Counsel.
As junior counsel, after concluding your substantive legal arguments, you will make an overall conclusion of your side's arguments. After that, you will request orders. As junior counsel for the appellant, you will ask that the appeal be allowed. Always conclude with, may it please the court. Those are our submissions.
We will now hear from the senior counsel for the respondent.
May it please the court. Your Honours, we are content to accept the facts as presented by our learned friends. We will be making 2 submissions. First, that the respondent is not liable because the appellant was engaged in a dangerous recreational activity. And second, that the respondent is not liable because the appellant was injured by the materialisation of an obvious risk. I will be addressing the first submission on dangerous recreational activities, while my learned junior will address the second submission on obvious risks. Always begin with "May it please the court." As senior counsel for the respondent, you may choose whether to accept the fact summary of the appellant or to summarise your own facts. Here, counsel has chosen to accept the appellant's fact summary as it is not biased towards any side. However, if you believe that the appellant's fact summary was overly biased or incomplete, you may also provide your own fact summary. Following the facts, you will outline the submissions you and your junior counsel will make. Your Honour, Section 5K of the Civil Liability Act states that any sport is a recreational activity. It is our submission that cycling, as a sport, falls within this definition. However, our learned friends submit that because the appellant was cycling to travel to university, it is therefore not a sport. In response, we would draw your Honour's attention to paragraph 5 of the facts, which states that the appellant cycles primarily for sporting purposes. It would be our submission that his intent to cycle to university afterwards does not alter the nature of cycling as a sport, nor is the intent to cycle for sport and travel mutually exclusive. Therefore, cycling in this case is a sport. As the respondent, you are expected to address the arguments made by the appellant. Therefore, it is important to read the appellant's written submissions to understand what their arguments are, and while the appellants are speaking, to listen carefully to what they say. Responsiveness can be demonstrated during a moot through counter-arguments. This is done by first identifying the specific argument to be countered, explaining why it is incorrect, and explaining then why your argument is correct. Do not spend time addressing arguments the appellant agrees with. Focus on the issues that are contested. Your Honours, the appellant was therefore engaged in a dangerous recreational activity, as cycling is a sport and poses a significant risk of harm. I will now kindly pass on to my learned junior, who will address submission 2 on the materialisation of an obvious risk. May it please the court, those are my submissions.
I will now hear from the junior counsel for the respondent.
May it please the court. Your Honours, I'll be addressing submission 2 on the materialisation of an obvious risk. Overall, as cycling to university is a dangerous recreational activity and an apple core being thrown out of a window is an obvious risk, the appellant was therefore injured by the manifestation of an obvious risk of a dangerous recreational activity. Thus, the respondent is not liable for the injuries of the appellant. We ask that the appeal be dismissed with costs. May it please the court. Those are my submissions.
Thank you, counsel.
As junior counsel, after concluding your side's substantial legal arguments, you'll make an overall conclusion of your side's arguments. After that, you'll request orders. As junior counsel for the respondent, you will ask that the appeal be dismissed with costs. Always conclude with "May it please the court." Those are our submissions.
When the moot has concluded, you will be asked to leave the room for several minutes while the judges deliberate. After they have finished, a winner will be announced and the judges will give general and specific feedback.